Which is your lordship. I beg to mention item number 17 on behalf 17 hearing matter on behalf of B. Bhagavati Madam, am I first? He is not available in the station today, madam. That matter may be passed over for that day.
MS Sam Gorman, Learned Counsel, appearing for Mr. B. Bhagavati, Learned amicus curiae. As submitted that Mr. Bhagavati is out of station. And the appeal will be listed after which MSB Priya. And additional public prosecutor. For the respondent state is present and has no objection to safeguard.
Okay.
Please, sir, it's item number 9, my lord. 9, my lord, from the orders column, my lord. We have been served a copy to the PP, my lord. Today we will serve the copy regarding this. matter,
Paper
my
book.
lord.
Huh?
They said they'll prepare a compilation
ma'am.
in order to
Yeah.
persuade, treat in
We
an
haven't filed,
application.
my lord. Today we will file, my lord. Let the matter come after a week, my lord.
Okay, Mr. D. Bora. Oh, you are saying it, huh? That was really happening.
Thirteen five orders.
Yes, my lord.
Okay, Mr. D. Bora. Learned Counsel appearing for the appellant. Appellants. Has submitted that the compilation. In reference to the order dated 13/5/2024. Will be filed during the course of the day. With copy. To the Learned Additional Public Prosecutor. As the state for listing of the case after a week. MSB, Learned Senior Counsel and Additional Public Prosecutor is present. And does not have any objection. Come, I'm the fair is. Absolutely. Where as paid for, leave the case.
God bless.
May I please the lordship? Your lordship, I beg to mention on matrimonial appeal for listing lordship.
Listing for orders,
Yes, lordship.
orders. Okay.
Can it be on Monday?
Let me do.
May I please your lordship? Lordship, I am for item number 18.
18.
Yes, lordship. Lordship, the matter has been listed after a long time, so kindly give us some time. Last it was listed on 2022.
Where is amicus? You are appearing for amicus,
Yes, on behalf of P. Mahanta.
P. Mohanto. Yes,
M. Borgohain.
Learned Counsel appearing for Mr. P. Mohanto, Learned amicus curiae. The appeal. A case stands adjourned for a week. As the pair is not opposed by MS and last Learned Additional Public Prosecutor for the respondent state of Assam.
Much obliged.
Daily list for admission item 1.
Single man.
May I please? This is a appeal from jail, lordship. Offense under section 302, 34 IPC. Offense under section 302 IPC and 34 IPC.
30234.
34.
Heard
I-
Mr.
I am the legal aid counsel.
Learned Legal Aid Counsel for the appellant. And MS and Das. Learned Additional Public Prosecutor. For the respondent number 1, state of Assam. Bill under section 370. Is April 370. Code of Criminal Procedure 1973 is directed against a judgment and order part.
Judgment dated 16/12 and order dated 20/12, 2023.
Judgment dated 16/12/2023. And an order on sentence dated 20/12/2023. Passed by the court, passed by the learned sessions judge, Kachar, at Silsor, in sessions case number 125 of 2018. Full stop. By the judgment dated so and so, the convicted for the offense under section 302 IPC, Indian Penal Code, read with section 34 from IPC, along with two other accused, co-accused persons. Full stop. By the order on sentence, comma. The accused appellant and the two co-accused persons is to undergo life imprisonment a fine of rupees 10,000 each, comma, in default to undergo simple imprisonment for 3 months each. The appeal is admitted for hearing. The case records of sessions case number 125/2018 we call for issue notice returnable in 4 weeks as MS Das, additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuance of formal notice is dispensed with. Extra copy of the memo appeal and now it's an extra. The accused appellant shall take steps for service of notice upon the respondent number 2 by registered postal AD within 3 working days.
Steps may be taken by the registry, Lordship.
Huh?
Steps may be taken by the registry.
No, you take the steps. I think, huh?
Obliged.
Attend to.
Lordship, there is a small typographical error in the cause title, Lordship. In default imprisonment in place of 3 months, it is written as 6 months, Lordship.
Okay. Didas. Accused appellant and us. Okay. It's 74-2, huh? It's a judgment. An order. Against a judgment dated 21/3/2023 and an order on sentence dated 22/03/2023. Special Judge Poxo Golaghat, 74-2, CRPC. A judgment and order dated
T03/2024.
30/3/2024, passed by the Court of Learned Special Judge within bracket Foxo Kokrajhar in
Special.
special case number 51/2018, comma, arising out of Bogriwari Police Station case number 81/2018, by the judgment and order dated so and so, the accused appellant has been convicted. Heard Mr. M. Rahman, counsel for the accused appellant, NMS N. Das, learned additional public prosecutor for the respondent number 1, State of Assam. The instant criminal appeal under section 374(2) CRPC is preferred against a judgment and order dated. The judgment dated 27/3/2024 and an order on sentence dated 30/3/2024, passed by the Court of Special Lakhimpur at North Lakhimpur in special within bracket NDPS case number 3/2023. So by the judgment dated so and so, the accused appellant has been convicted. Which a co-accused for the offense under section 20 within bracket small b within bracket small Roman 2 bracket close within bracket capital C bracket close stroke section 29 of the Narcotic Substances Act 1985. The accused appellant has been sentenced to undergo rigorous imprisonment for 14 years and to pay a fine of rupees 1,20,000, in default of payment of fine to undergo rigorous imprisonment for another 1 year. Appeal is admitted for hearing. The records of so-and-so case number, the case records of so-and-so case number be called for issue notice returnable in 4 weeks as MS Das appeared accepted. Respond number 2. Who is respond number 2?
Informant.
Informant? Police officer or what? He is police officer. You can represent. Appear and accept a notice for both the respondents. IA. M. Rahman, applicant appellant for both the respondents. Both the opposite parties. This is an application under section 389 CRPC seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail. Post of the applicant as the appellant has preferred the connected appeal from a criminal appeal number 159/2024 against the judgment and order dated so order issue notice detail conviction to be issue notice as MS Das has appeared and accepted notice on behalf of both the opposite parties issuance of formal notice and dispense with extra copies within 3 working days. We want to file objection.
Yes, Lordship.
Same objection on or before the return. The application will be considered after receipt of the trial court reports.
For orders, item 5.
May it please your lordship. Lordship, we have not received the paper book.
Service report officer in charge. I see, I see. 302. Service. Service is complete. Appeal admitted. You are amicus.
Amicus M. Datta, on behalf of Amicus M. Datta.
Why amicus is not, who is amicus? M. Doctor.
He is in Lakes right now. We have not received the paper book also.
Hard and counsel for the parties. As per office note. Dated. 19. Sorry, 19, no. Twenty 05/2024, comma. Service. Report as the service of notice under respond number 2. From the officer in charge, Bihali Police Station, Bishwanath, Post Office. As the records of the trial court. Case records have been received, comma, the office to prepare the paperwork. Place the appeal after province.
Obligation.
Item 6.
As regards the paperwork.
Item number 6.
Conviction under section 302.
302.
LCR has been received. Paper book not furnished.
Report received. Hart MS B. Chaudhary. Planet Amicus Curie. And MS for the appellant. And MS and thus. Planet additional public prosecutor for the respond number 1, state of Assam. Post of. As the of the learned trial court. Having received command the office is to prepare the paperwork. Post of lista. Appeal after 4 weeks. With a report as regards the paperwork and service report in respect of respond number 2.
Item 7.
If your paper book is ready and learned advocate has also engaged on behalf of the respondent. Paper book is ready and the,
Paperwork ready.
yes, Lordship, pro bono advocate is also engaged for the respondent number 2.
Pro bono.
Yes.
Paying for the appellant and MS and thus learned additional public prosecutor for the respondent number 1, state of Assam. Post of. The name of the learned counsel representing the respondent number 2 is represented in the cause list. Post of. As the paperwork has been made ready, office to list the appeal for hearing. In due course.
Item 8.
Service is complete.
Yes.
POCSO.
POCSO, my lord.
389.
Oh, I am also the legal aid counsel.
Legal Aid Council. Objection filed.
They have already filed an objection.
Filed.
Yes, sir.
They are received.
Paperwork,
Offense is what? 302.
no.
Please, honorable court. Through my WhatsApp also, Lordship. Today also I tried to contact him, but no response has been received.
Okay. How much time? 1 week?
1 week, Lordship.
As the. NMS SH Bora. You write BORAH?
BORA, Lordship.
BORA.
Yes, Lord.
And additional public prosecutor. Assam for the opposite party. Press respondable. Okay, MS Bora has sought further 1 week time to obtain a report from the officer in charge to police station as regards service of notice upon the opposite party number 2. Place the case accordingly after which.
Highly
Yes,
obliged.
Lordship.
Item 12.
Question 5%.
Madam,
I am the informant, but the informant is expired.
informant expert. So
He has to produce
what
the
is
date
required to be
certi-
done?
He has to produce a date certificate, Lordship. It should be on record, Lordship.
Your records
It should be on record, Lordship.
to produce the date certificate
Produce course certificate, date certificate.
and who is to be.
Then Lordship may fix on Friday.
You want to submit any substitution application you make? Substitution
wife of the informant.
victim or aggrieved person, victim. Whoever falls in the category of victim. I think in such a case only it can be done. Okay, Mr. Chaudhary, what to do?
Lordship may fix on,
Give 1 week or 2 weeks time to file submit the date certificate and to file and an opportunity to file application for substitution if so advised.
Otherwise, Lordship, as per notification of this honorable court, Lordship, dated 13 March, Lordship.
Notification,
Inform,
notification, 17.
information, 302.
Otherwise, 302 better, Lordship.
Is this 302?
302.
Lordship.
Okay.
Stop record, perhaps.
302. Oh, it is only 302.
Yes,
Lordship, 302. Lordship, we fixed it on Monday, Lordship. Because I is there, Lordship.
You want, he has the opportunity to file any substitution, if so advised. Otherwise, we will proceed.
Lordship.
2 weeks time. maybe.
You proceed, otherwise we will be considering this application because there is no bar.
Yes.
Lordship, Monday. Lordship, Monday.
He has the participatory right.
Lordship.
But it is not obligatory.
It is not
Lordship.
obligatory.
Third, Mr. Ayu
Are
Chaudhary,
you?
learned counsel for the applicant appellant. And MS SH Bora, learned additional public prosecutor for the opposite party number 1, State of Assam. Full stop. Mr. N. Ahmed, learned counsel, who is to represent the opposite party number 2, that's informant, has submitted, on instruction, that the opposite party number 2, that's informant, has expired recently Recently,
Yes.
recently, full stop. He has thus submitted that the case be listed after 2 weeks in order to obtain, in order to enable him to obtain instruction to place a copy of the death certificate and to file any application for substitution, if so advised. So, stop. As the offense involved is the prayer made by Mr. Ahmed is allowed with the observation that in an event no substitution application is filed, the instant application will be considered on its own merits.
All right.
On or before 2 weeks, on or before, the instant application will be considered on its own merits.
All right.
Will be taken up for final consideration. On its own merits. Basically, I do.
Item 30.
Yeah.
Item 14.
Legate the appellant's text in
Fourteen
reference
also, Lordship, service
to
report is awaited.
publication, restriction, Barpeta Road Police Station.
Service
Yes,
report awaited, Lordship.
await it.
Yes.
It has written answer, my lord.
There's no problem.
Yes.
No, MS Bora is to obtain the report from the officer in
concerned
charge.
OC, Lordship. That is awaited, Lordship.
Mr. R. Ali, learned counsel for the applicant appellant, and MS SH Bora, learned additional public prosecutor for the opposite party number 1, State of Assam. MS Bora has submitted that she is yet to receive the report from the Barpeta Road Police Station as regards service of notice upon the opposite party number 2. Post up on the prayer of MS Bora. Please the case after a week
Lordship.
or to enable MS Bora to obtain the report as regards service.
All right, Lordship.
Item 15.
May it please your lordship. Here in this case, service is complete, but LCR not received, lordship.
It means appeal. We cannot notice. Notice.
Service
My father and mother. Promise to report it. Yes, anything to be added?
Lordship, I'd like to place one judgment on how there's an on section 161. It's of our High Court only. I have only one copy. May I give the citation, Lordship?
How to, tell me the ratio. You tell me the ratio.
May I read it out, Lordship?
Read louder.
Yes, Lordship. It's at paragraph 1.
COVID-19 cannot be an excuse.
Yes, Lordship. It's Criminal Appeal 261 of 2017, Lordship, of our High Court, para 132. We further hold that the procedure adopted by the trial court in exhibiting the previous statements of the witnesses who were declared hostile and were confronted with the same by the prosecution in cross-examination is absolutely lackadaisical, flawed, and is fatal to the case of the prosecution. A previous police statement of a witness recorded under section 161 CRPC cannot be proved in evidence as per the embargo contained in section 162 CRPC. However, such previous statement may be used to confront the witness or to corroborate his evidence as provided under section 145 of the Evidence Act. In this regard, we may refer to the procedure provided in section 145 of the Evidence Act, which deals with cross-examination as to previous statements in writing. This section can be split up in two parts. The first part talks of cross-examination of a witness as to previous statements made by him in writing or reduced into writing and relevant to the matters in question without such writing being shown to him or being proved. The second part of section 145 provides that if it is intended to contradict the witness by the writing, his attention must, before the writing can be proved with quoted, be called to those parts of it which are to be used for the purpose of contradicting him. The second part is applicable to the case at hand because the witnesses concerned upon their attention being drawn to the relevant parts of the previous statements under section 161 CRPC denied the same. In such circumstance, the writings were required to be proved by marking exhibit upon the original statement of the witness recorded in the section 161 CRPC/164 CRPC and marking quotations upon the confronted portions as A to B, B to C, and C to D, so forth, so on. Then para 133. The previous statement of a witness recorded under section 161 CRPC falls within the definition of a document. If portions of the said document are to be used for confronting or contradicting the witness under the later part of section 145 of the Evidence Act, then this document, that is the previous statement, would have to be tendered and proved in evidence by marking an exhibit thereupon during the deposition of the witness concerned as well as the scribe investigating officer, so as to accept the admissible part thereof as legal evidence. However, neither the prosecution nor the trial court took the trouble of exhibiting and marking quotations upon the relevant parts of the previous statements of the witnesses during the testimony, and since the statement itself being a document was not tendered in evidence and proved the entire procedure so undertaken by the trial court is fraught with irregularity and illegality. The procedure how to prove the previous statement, which is proposed to be used for contradicting or confronting the witness under section 145 of the Evidence Act, was elaborated by Division Bench of this court in the case of Gautam Das and another versus State of Tripura and another reported in 2008 3 GLT 625. The relevant observation is made below, Lordship. Lordship, I have one copy. I can use the from.
it was. Oh, okay. Yes, MS Bora. Anything?
Lordship, I have a small submission. Lordship, the present case in hand is based on circumstantial evidence, Lordship. So to that regard, I just want to put the attending circumstances on the basis of which cogent and complete chain of circumstances is completed on and forming a basis of conviction for the accused, Lordship. So like, in very nutshell, Lordship, in very short, I just want to give the,
So chain of circumstances are there.
yes,
Now, one is, there is nothing as regards motive.
yes, Lordship,
In a case of circumstantial evidence, motive is of significance.
Yes,
Otherwise,
Lordship.
there is no enmity.
yes.
Like nobody has said about
Yes,
any enmity
otherwise.
otherwise, any independent witness. And yes, it is not exactly a situation that they were alone inside the house.
Yes,
There were the PW2 was also there.
yes,
Then another son was there. He may be a minor.
yes,
Now PW2 became hostile.
Lordship,
And as I've been submitted, the procedure
yes,
to bring out the contradiction
yes,
was not followed.
Lordship,
So the prosecution can refer to only that part
Lordship,
of those witnesses, even if declared hostile,
yes, Lordship.
which are in support of the prosecution. case.
Prosecution case, Lordship,
Now,
It
if
is-
we test those remaining part,
Lordship,
that appears to be not sufficient to bring home the charge, then it could be a situation
Lordship,
that right to remain silence on the part of the accused is preserved to him.
Lordship,
He may choose to remain silent.
Lordship,
But in some situation, there is some necessity to offer explanation,
Lordship,
like Maruti
yes,
Kirkan 106.
yes,
But
106.
this is not exactly.
Yes,
But here in his 313,
yes,
he offered some explanation.
yes, Lordship. He has stated that somebody else has, some miscreants has entered in his
Ah,
house and attacked his wife.
And he was sleeping in a different room.
Yes,
So, in such situation, whether it could be a plausible issue,
so
that is to be tested.
yes, so that regard, Lordship, we just want to,
If two hypotheses possible now,
yes,
then the benefit
goes to the accused.
goes to the accused.
Yes,
So these are the situation.
and
We have
Lordship,
to go by the legal theories.
otherwise.
Okay.
And Lordship, that is remain unrebutted that conversion has been heard by PW2, which is also supported by PW5, Lordship.
Now, there is nothing about light.
Lordship, the question number
Because
3,
in his explanation, 313, he said, I was sleeping in a different room,
different room,
heard
but
clamor of my wife
yes,
asking me to come near her. Then he lit a lamp.
and her one portion is on the bed and the other portion is,
Night
yes,
with lights off is more normal than sleeping in bedroom
yes,
with light on.
yes,
And we don't know whether there was electricity or not.
that is true also.
So midnight,
So,
that
Lordship,
is also doubtful now.
so one more thing, Lordship,
Because lights on and lights off.
yes,
Suppose there is electricity, there
Lordship,
is not nothing. Prosecution has brought nothing
nothing, to
about
that record,
existence of electricity.
Lordship,
Even if electricity is there,
Lordship,
sleeping in your bedroom with
Yes.
lights off is more normal
yes,
than with lights on.
yes, Lordship,
PW2
Hmm.
stated nothing. On the other hand,
yes, Lordship,
the accused has said he was sleeping in a separate room.
separate room,
Wife called him. He found
Hmm.
after lighting a lamp,
yes,
meaning thereby there was darkness.
there was darkness,
Yes,
He tried to protect.
plausible,
Hmm.
offer some plausible.
Yes, subject to correction, Lordship. To that extent, I just want to put my view, Lordship. Lordship, he has stated that he and his wife was sleeping in a different room. And with his wife, his children were sleeping, Lordship. And after hearing the sound from his wife, he rushly came to her room and lit the lamp and found her body was lying on half on bed and half on the floor. Thereafter, he has asked her what had happened, but she couldn't reply to him.
He lit the lamp before, Lordship.
Lit the lamp, and thereafter he has seen the occurrence. But thereafter, he has asked his daughter to call his uncle, that is PW3. But Lordship, while PW2 was given statement, deposed in her statement, he didn't even utter a single word in of the presence of any third person. That's somebody has killed my mother. So that is not their Lordship. Just before leaving to call her uncle, her mother has already sustained injuries.
She also left something blank.
Yes. So there is, and if
She
was
had the
sleeping-
clamor of her parents,
Yes,
both her parents.
yeah, both are parents. That is the problem.
Whatever is remaining
Yes,
after declared hostile.
yes.
What
Yes,
is,
what
what
was-
is remaining is that she wake up
See, wake up,
hearing
screaming of
clamor of her parents.
parents.
Both.
Yes. And she has nothing, she didn't utter a single word. That somebody has killed my mother, assaulted my mother. That is not there from her evidence. And Lordship, if for a moment, if we assume that the statement of the accused under section 313 is correct, assuming for a moment, then she would be the right person. She would be the most reliable person to say that somebody else had entered in our room and assaulted my mother because she was sleeping with her mother. So to that regard, she did not utter a single word.
So then benefit will go to whom?
Yes,
Benefits would go to whom?
the accused,
That is one
one
part.
respect.
Two hypotheses are most
Yes, Lordship.
possible to be drawn.
Yes.
That it was accused or somebody else.
Yes.
Strong suspicion is there. And because of this hostileness
But
and
it
some
can-
failure on the part of the prosecution also.
yes, it can be accepted up to that extent.
Because law
up to
is,
which it is
law is
supported.
clear what MS Devi has read.
Lordship,
If
otherwise,
you want to confront,
that is 161, 162.
to
and
draw contradiction for the benefit of the prosecution, then
Lordship.
he has to be drawn attention to those parts of his previous statement, then that has to be marked, then that has to be again put to the IO.
Lordship,
Then it may be read.
there is a procedure otherwise.
Okay, we'll pass the order with the benefit of the to the
Okay. Otherwise,
appellant.
highly approved.
After writing, I will pass.
Lordship.
Item 20.
Kali to aid. Yes, sir. Okay.
Yes.
উইটনেছবোৰ ক'লো, এতিয়া আমি এনালাইচিছটো কৰি আছিলো না। এইটাতো ডিছকাৰ্ড কৰিলো ন, এইটা হষ্টাইল কোৱা নাই জানো, হষ্টাইল বুলি ক'লো না, প্ৰথমতে কৈছো হষ্টাইল সেইকেইটা, আৰু সেইকেইটাই হেৰি এগেইনষ্ট একো কোৱা নাই, এই ইটোৰ এগেইনষ্ট মতা লেভৰ এগেইনষ্টে কৈছে বুলি কৈছিলো। চ' আমাৰ কোনো পাৰপাছ নাই তাতে, আৰু আদাৰৱাইজ অলছ' এইটো প্ৰচিডিউৰ মতে একো কৰা নাই বুলি কৈছো কিবা এটা। প্ৰথমে আমি কৰিলো হোষ্টেল কৰি পেলাই ভালকে কৰিব পৰা নাই, আৰু ইন মেটাৰ এই মতা লগত কেনেকে এড কৰিলে সেইটো বিষয়ে কৈছে। PW8 PW8 নহয়, PW8ৰ পিছত PW7 নহয়, PW7টো পুতেক আছিল নেকি, PW7 পুতেক, ইয়াতে PW7টো নহয়, PW10 PW7টো কাৰেক্ট কৰিব। এইটটো আছে, PW9 নহয়, 9টো ডাক্তৰ, 10 সিৰাজ আলী, আৰু 11 11 10 আৰু 11 কাৰেক্ট কৰিব। প্ৰতিটো ছাবজেক্টৰ সেইটো ছাবজেক্ট আছিল দেৱ সিং, he last level data scene were tried under charge of section 302 34 IPC for the murder of Ansu Sassi. The trial court acquitted data scene, Kurako acquitted and convicted Sukhdev Singh appellate for the offense under section 302 IPC and sentenced him to so and so. The state did not file any appeal against the order of acquittal. Sukhdev Singh appealed against his conviction. Court altered the conviction of Sukhdev Singh to one under section 302, related with 34 IPC and maintain the sentence. Hmm? This appeal by specially is directed against the judgment. The High Court. 34 is what they're putting. 34 down. It will pay the. Maybe a quick, right? A quick. Yeah. What বিভিন্ন submission দিয়েছিল therefore the order of acquittal of presence has become final. There no appeal has been signed by the state. Challenging us. He was filed by Shukdev Singh. Means the conviction it was contended before the High Court and done in signature the prosecution units. That's the conviction of Shukdev Singh on the same reason for sustained contention advance submission. It is also contended on the charge of conviction of the section 2 of IPC. There was valid law and view of acquittal of Tejas was placed to have delivered the fatal. What are the Tejas in the water? Was alleged to have delivered a fatal. The defendant should not be convicted with the aid of section 34. The most secretive found guilty for I could have maintained for rapid length into a road of 3 units. This is a special leave for the defense of science. The High Court has previously erred in recording the conviction to IPC with the aid of section 34 IPC on the acquittal of Tejas, the element of sharing the communication decision. There was no scope for invoking against the appellate. Any constructive liability intercepts. We shall now examine whether the approach made by the High Court in judging the use of the evidence. The person also participated in the offense as introduced any optional. MS, where you refer to Brathi.
My lord.
Ah.
That in absence of appeal preferred by the state when co-accused has been,
Right. That
yes.
was a case,
Yeah.
just because
Lordship.
it was a case where one nephew and uncle were charged for the offense under section 302/34.
My lord.
The uncle was instrumental in giving the fatal blow. But the learned trial court acquitted uncle. Nephew remained. And he was convicted under 30234.
Motion.
Then state did not prefer any appeal against the
Order of acquittal,
acquittal of the uncle.
my lord.
Then nephew preferred an appeal before the High Court. High Court maintained the same.
Order of conviction.
Then it went to the Supreme Court. Now, paragraph 8 is vital. You read because Sundar Singh assumes importance.
Yes, right, my lord.
Para 8. This is the story.
Yes.
And you read yourself.
Motion.
এখানে কারেকশন করতে হবে এখানে কারেকশন হবে এটা দেখি Acquitted, foiled. On a repetition of the evidence and something like it. You know, acquitted. You appellate for it, trial for it. Precision was suppose happening, observation zero better. But here it is coordinate. That's something need to be respected. Find out. On a it could not interfere with such a case in the absence of an appeal by the state. And to afford in advance. We have to accept. No, no, ঠিক আছে এখানে মনে হয় যেটা স্টোরি বলছে আর পেলার দেখি মেটাল বম মানে কি বিয়ে ইয়াতো মশা লাগে এই করছে কথা বলে নিতে যে রূপ পাউলাই ও কিবা আমার এটা ইন্টারনেট করে Now, have you understood?
Lordship.
1 minute. Underline Sundar Singh. Sundar Singh.
Lordship, may I read slowly? Should I? It
Is
is
Sundar Singh.
in Sundar Singh case, this court has held that the provisions of section 423(1)(a) do not create a bar against the appellate court considering indirectly and incidentally a case against the person who was acquitted. Lordship?
Uncle.
Yes, uncle. If that becomes necessary when dealing with the case in the appeal presented on behalf of the other accused who are convicted. In considering the evidence as a whole, the appellate court may come into the conclusion that the evidence against the person acquitted was also good and need not have been discarded. When several persons are alleged to have committed an offense in furtherance of a common intention and all except one are acquitted, it is open to the appellate court to find out on a reappraisal of the evidence that some of the accused persons have been wrongly acquitted, although it could not interfere with such acquittal in the absence of an appeal by the state government. The effect of such finding is not to reverse the order of acquittal into one of the conviction or visit the acquitted person with criminal liability. The finding is relevant only in invoking against the convicted person his constructive criminality. So Lordship may still consider, yes, I will be wrong in understanding. Yes,
Uncle was acquitted by the trial court. State did not prefer appeal. Nephew was convicted under 302, read with 34.
35.
Nephew preferred an appeal. Right? Now, High Court as well as Supreme Court. High Court as an appellate court reappraised the evidence and found out that uncle should not have been acquitted.
But yeah,
Please.
yes,
He should also be. So his thing was considered, his participation, role, everything was considered along with nephew. Then High Court maintained the conviction. Right? Now, two, 3 words. It is open to the appellate court, right? Please read
I'm
properly.
getting it. Oh, yeah,
1,
got
2,
it.
3,
It is-
4, 5,
Found
6,
it, my lord.
7, 8.
Yes,
Huh?
it is open to the
Please,
appellate court.
all except one are acquitted, right?
Yes,
Here,
on
it is open to the
the
appellate court
court
to find out
out.
on a reappraisal of the evidence that some of the accused persons have been wrongly
Wrongly
acquitted.
acquitted.
Please pause
My lord,
for the appellate court
my lord.
to find out one has been wrongly acquitted. Now, in our case, Motaleb, we are not appellate court. We are coordinate court.
Yes,
That is the difference.
yes,
Coordinate bench has acquitted Motaleb.
yes,
Now, the law is also settled that judgment of coordinate bench is to be respected and not to be criticized. If you have another view, you have to
go to
refer
the
it to larger
larger bench.
bench. Right? So, this proposition that when Motaleb has already been acquitted, I think
Lordship is binding.
it is
on-
not open for us to criticize
Yes,
his acquittal.
my lord.
We have to respect the acquittal of Motaleb.
Motaleb.
So since he got acquitted, he has got acquitted already. Whatever is there against him, we cannot read to find out his culpability.
Other
Because we are
person,
not appellate court, please remind.
Lordship, regarding Motaleb, then remains the present
Remains
appellant.
his
Present appellant.
wife.
Yes. So
why-
without, so my
His
son,
proposition.
yes,
I have read this paragraph 8 time and again, and we found that we are not appellate court. We are coordinate court. Had trial court been acquitted Motaleb, we could have criticized as an appellate court
Lordship.
because the proceeding is in continuation of appellate proceeding is
Lordship.
to be treated as continuation of the original
my
proceedings.
lord,
But here it is not.
not. Lordship,
We-
so my submission would be,
That submission
Lordship
will not.
may not look into whether he was correctly acquitted or not. The Lordship may, yesterday I made a submission, the case against the evidence against the present appellant is that she was the wife, she was all along present there.
So this, I think, this is to be, there has to be some observation that we as a coordinate bench is to, judgment of the coordinate bench is to be respected. Because this proposition is not applicable in the case in hand.
Yes, but your Lordship independently can,
Yes, the discussion there,
yes,
and we'll proceed. Whatever is available with.
yes, so in his case, he's not the inhabitant of that house, the other one, but she is the one who was an, yes, yes.
But this proposition.
yes.
On a scrutiny, I have found that
Yes, I think Lordship is very much correct.
this is not. Otherwise, it would have been open for us to decide culpability of Motaleb also had trial court acquitted him. But he has been acquitted by coordinate bench.
My lord. Your lordship
And
is right, sir.
jurisdiction is same.
Yes,
Our jurisdiction is not appellate
my lord,
to our coordinate bench.
Lordship.
We cannot sit in appeal
my lord.
over the judgment of the coordinate bench.
Correct, your lordship. Correct view.
So we cannot make any comment on
My
him.
lord.
His culpability also.
Yes, my,
Right.
my lord.
Any incriminating material, we cannot make any comment.
Lordship.
So we'll proceed.
I missed that, lordship.
No, I thought that whether
Right,
we can
profession.
do it or not.
My lord.
But then I went to the facts.
Yes,
Then I found.
my,
Close first. Record. MS Bhuya, learned it. Addition public prosecutor has referred to the decision of the Honorable Supreme Court of India in Brathi Elias Sukhdev Singh versus State of Assam or Punjab, reported in 1991, 1 SSC 519. Post up. The factual matrix in that case was that the appellant and his uncle, Teja Singh, were tried on the charge under section 302/34 IPC, para 1 of 2002. For of murder of one Sucha Singh, the trial court acquitted Teja Singh and convicted the appellant for the offense under section 302 IPC and sentenced him to undergo imprisonment for life with default and to pay a fine. Pay a fine. Full stop. The state did not file any appeal against the order of acquittal of Teja Singh. Full stop. The appellant preferred an appeal against his conviction before the High Court, and the High Court, as an appellate court, altered the conviction of the appellant to one under section 302 IPC read with section 34, IPC and maintained the sentence. Full stop. The appellant by special leave approached the Honorable Supreme Court. Full stop. It was contended that the order of acquittal of Teja Singh became final as no appeal was filed by the state challenging the same. It was apprised. It was thus contended that the conviction under section 302, conviction of the appellant, the appellant could not have been convicted for the offense under section 302 IPC with the aid of section 34 in view of acquittal of Teja Singh. Full stop. It was in that background. So it was in such a background, the Honorable Supreme Court of India has observed that the powers of the appellate court in dealing with an appeal against an order of conviction are defined under section 386 within bracket 1, within bracket B of the code. I mean, the code question, no? Full stop. It has been observed that in the matter of appreciation of the evidence, the powers of the appellate court are as wide as that of the trial court, and it has full power to review the whole evidence. Full stop. The appellate court is entitled to go into entire evidence and all relevant circumstances to arrive at its own conclusion about the guilt or innocence of the accused. Full stop. A reference has been made to a decision, another decision of the Honorable Supreme Court in Sundar Singh
AIS 62 minor.
what is the full name? Sundar Singh versus State of Punjab, reported in AIR 1962 SC 1211. 1211. So in Sundar Singh, it is held that the provisions of section 423 within bracket 1 within bracket small a, CRPC, a perimeter, a provision perimeter to section 386 of the code, do not create a bar against the appellate court considering the indirectly and incidentally a case against the person who was acquitted, if that becomes necessary when dealing with the case in the appeal presented on behalf of the other accused who are convicted. Full stop. It has been observed that in considering the evidence as a whole, the appellate court may come to the conclusion that the evidence against the person acquitted was also good and need not have been discarded. Full stop. When several persons are alleged to have committed an offense in furtherance of the common intention, and all except one are acquitted, it is open to the appellate court to find out on a reappraisal of the evidence that some of the accused persons have been wrongly acquitted, although it could not interfere with such acquittal in the absence of an appeal by the state government. The effect of such a finding is not to reverse the order of acquittal into one of conviction or visit the acquitted person with criminal liability. Full stop. The finding is relevant only in invoking against the convicted person his constructive liability. Full stop. Criminality. Full stop. Such full stop. In our considered view, the proposition laid down in Brathi Supra and Sundar Singh Supra is not directly applicable to the case in hand, full stop, as has already been mentioned here in above, comma, the co-accused person was convicted.
Yes.
Is not directly applicable, full stop. In the case in hand, comma, the learned trial court
Was complete.
convicted both the accused persons by a common judgment and order of conviction and sentence dated 27/10/2017. Also, both the accused persons were convicted under section 302/34 IPC. Full stop. On being convicted, comma, both the accused persons each of the accused person had preferred appeal independently, had preferred separate appeal, had preferred to separate appeal independently. Full stop. The co-accused person, as has been mentioned here in already, as has already been mentioned here above, comma, in above, comma, the co-accused person has been acquitted by order
22/4/2019, order dated.
by an order, judgment and order dated 22/04/2019, passed in criminal appeal number 37/2018 by a coordinate bench. Full stop. It is right. It is also settled. It is also well settled that a judgment of a coordinate bench is to be respected. Is to be respected. And is to be respected. Full stop. Meaning thereby, like an appellate court, comma, a coordinate bench of the same court should not should not embark to find out on reprisal of the evidence that any of the co-accused persons had been wrongly acquitted by the coordinates. we rest the discussion on this aspect here. We will not say anything. Is the paragraph 36.
Six of aesthetics.
The learned trial court. Based. Learned trial court had referred to the testimonies of the two prosecution witnesses three prosecution witnesses, PW3, PW5, and PW10. To reach a finding that the prosecution is unable to prove an extramarital affair between the accused appellant and the co-accused. Full stop. Continue. Therefore, it requires a consideration of the testimonies of the said three prosecution witnesses. Full stop. PW3 in his testimony, deposed to the effect that he had a suspicion in his mind that before the incident, the deceased found the present accused appellant, and the co-accused person moving around together, and there was a quarrel on that issue between the deceased and the present accused appellant. Full stop. He had a suspicion that out of the said quarrel and relationship, the present accused appellant and the co-accused killed the deceased. Full stop. PW5. In his evidence in chief, deposed that he had a guess that the present accused appellant had killed with the help of the co-accused person. Full stop. When cross-examined, PW5 stated that he saw the two accused persons moving together in and around their village. Full stop. PW10. Did not state anything regarding the alleged relationship between the two accused persons from his own knowledge. Full stop. PW10 had only stated that people had seen the two accused persons. Oh, no, not on his own all knowledge, no. He saw the two on his own knowledge, no, based on not based on hate, no. নতুনকে লিখিত কাটি দিওঁ PW10 deposed that he saw both the accused persons moving together on bike and the deceased and the present accused appellant had a quarrel on that issue. Full stop. In his cross-examination, PW10 stated that he draw a suspicion on the basis of information received from the village people. Full stop. It is clear that sorry, the three is the same three prosecution witnesses, PW3, PW5, and PW10 had only seen the two accused persons moving together. Full stop. Their suspicion as regards an extramarital relationship between the two accused persons was based on the fact of only on the fact that they had seen the two accused persons moving together. Full stop. it is to settle a law that mere submission or even a strong suspicion, cannot take the place of proof. Full stop. As per Oxford Dictionary of English, third edition, quote unquote, extramarital means within bracket, basically, and means an extramarital affair, especially of sexual relations occurring outside the marriage. Full stop. In the considered view, in our considered view, the the learned trial court had observed that the conduct and behavior of the two accused persons, that is, the present accused appellant, two accused persons, that is, the act of moving together, which raised eyebrow of the general public, was sufficient to establish extramarital affair. Full stop. The learned trial court had gone on to observe that the same such conduct and behavior had proved extramarital affairs between the two accused persons. Full stop. In our considered view, the learned trial court had erred in drawing such conclusion on the basis of the testimonies of PW3, PW5, and PW10, who had only suspected about an extramarital affair. Full stop. Para. It is not in dispute that at the time of the incident, the present accused appellant was present inside the house where the act of assault on the deceased had occurred. Full stop. apart from the present accused appellant, comma, PW
PW
three,
four,
PW four,
Sir.
daughter,
daughter is PW
PW four,
4 and 7 divided.
and PW seven, comma, that is, comma, the daughter and the son of the present accused appellant and the deceased were also present. Full stop. The daughter, comma, PW four, that had clearly stated, had clearly testified that had deposed, had deposed that she woke up from sleep after hearing her mother's cry. And waking up, comma, she saw her mother sitting next to her father, sitting and crying loudly, sitting next to her father. Full stop. PW4. At that time, comma, her mother, that is the present accused appellant, was crying loudly. Full stop. PW 7, comma, the son of the deceased and the present accused appellant, comma, was sleeping on the other room, in the other room of the two-room house on that relevant night. Full stop. PW 7, in his testimony, comma, stated that he heard commotion of his mother and his sister on that, he wake up hearing, he wake up on that relevant night hearing alarm raised by his mother and his sister. Post of hearing the alarm, comma, he came out of his room and found his father lying dead on his bed. Full stop. BW six, who was the Damura of the village, had deposed that the present, the accused appellant and the deceased had good relation. Full stop. Though good relation, full stop. Good relation. Full stop. তার আগত লিখিব এইটোৰ লাইনৰ আগত the conduct of the accused appellant on the presence of the accused appellant inside the house along with her children and her husband was quite natural. Full stop. When both the children had stated that they found the accused appellant raising alarm and crying near the body of her husband, which was also quite natural for a wife. I'm sure Gamura লিখে দিব। আর কি করেছে? G2 the circumstance No, sorry, the act of crying by sitting. Act of crying by the accused appellant by sitting near the dead body of her husband, who was considered to be a circumstance was considered to be one of the circumstances to draw an adverse inference against the accused appellant. uh, Cannot be treated as a link in the chain of circumstances full stop. The, 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 uh, IPC. The learned trial court, there, in the absence of any overt act, the absence of any evidence as regards any overt act, OVERT, overt act on the part of the accused appellant in the act of assault on the deceased, the learned trial court drew certain inferences of common intention কি গুলো drew huh? Oh. The basis of certain circumstances, age, para 30 আছে কন্টিনিউয়াস করে দিব A B C D E F Yeah, 30. These are the circumstances. A, B, C, D, E, they can type it. As per section 34 from IPC, when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. Full stop. Section 34 IPC carves out an exception from the general law that a person is responsible for his own act, as it provides that a person can also be held vicariously responsible for the act of others if he has the common intention to commit the offense. Full stop. The phrase, quote, common intention, unquote, implies a prearranged plan and acting in concert pursuant to the plan. Full stop. The common intention must be there prior to the commission of the offense in point of time. Full stop. The common intention to bring about a particular result may also develop on the spot as between a number of persons with reference to the facts of the case and circumstances existing thereto. Full stop. The common intention under section 34 IPC is to be understood in a different sense from the same intention or similar intention or common object. Full stop. The persons having similar intention, which is not the result of the prearranged plan, cannot be held guilty of the criminal act with the aid of section 34 IPC. Full stop. The establishment of an overt act is not a requirement of law to allow section 34 to operate, inasmuch as the section gets attracted when a criminal act is done by several persons in furtherance of the common intention of all. Full stop. What has, therefore, to be established by the prosecution is that all the persons concerned had shared a common intention. Full stop. The ingredients of section 34, that is, the accused had acted in furtherance of their common intention, is required to be proved specifically or by inference, in the facts and circumstances of the case. Full stop. Either from the common intention or the intention of the individual concerned in furtherance of the common intention could be proved either from direct evidence or by inference from the acts of attending circumstances of the case and conduct of the parties. Full stop. The ultimate decision, at any rate, would invariably depend upon the inferences deductible from the circumstances of each case. Full stop. No hard and fast rule can be made out regarding applicability or non-applicability of section 34 IPC. The section, section 34 is only a rule of evidence and does not create a substantive offense. direct proof of common intent, such intention can only be inferred from the circumstances appearing from the proved facts of the case and the proved circumstances. Full stop. None of the circumstances are referred to by the learned trial court. Comma, in the considered view of this, in our considered view, comma, go to proof that, go to establish anything that there was any element of participation in action on the part of the accused appellant hearing. Full stop. It's needs reiteration that the co-accused person has already been acquitted from the charge under section 302/34 IPC. Full stop. It is submitted at the bar that no appeal has been preferred
No, sure, I have no instruction actually.
as on date. As on date.
I have no instruction as such. My submission, generally it may be.
Full stop. Nothing has been brought
Yes.
on record.
Yes.
To show that any appeal has been preferred against the said judgment and order dated so and so, past in criminal appeal now so and so, acquitting the co-accused person. Full stop. The evidence sorry, upon making a comprehensive analysis of the entire evidence stock materials on record, comma, we find nothing inculpatory on the part of the accused appellant. In the absence of any direct overt act or indirect or any element of participation in the act of assault on the deceased. Full stop. The inferences, circumstances on which the learned trial court had relied on, are found to be not sufficient to draw any conclusion of guilt with regard to the killing of the deceased in the above fact situation obtained in the case, the instant the criminal appeal succeeds, also resultantly, the judgment and order dated so and so passed by the learned trial court insofar as against the present accused appellant is concerned. Full stop. Para. It is to be set forth at liberty if not required in connection with any other case.
One submission as regards 313 Shikep Mom. Can it be observed?
Huh?
In 313 Shikep Mom, although she was there.
Okay.
Anything?
Submission order লিখিত হবে। Did not offer any explanation of it or 313. Amicus? Oh no, you are not amicus. Amicus. Earlier appreciation, remuneration, then trial court request be sent.
She's in jail also, man.
Forthwith.
She's in custody, man.
To be released on bail, to be released forthwith, but she'll not be released today.
And then not sure.
It needs some correction.
For some
So maybe Friday or Monday.
Yes, Mr. Doctor. May I please, Your Lordship? My Lord, this is, my Lord, the appellant, my Lord, he has been convicted, my Lord, of killing his brother. And my Lord, the prosecution does, my Lord, examine many of the witnesses. My Lord, the wife of the deceased is a prime witness, my Lord. She is supposed to be the eyewitness. And my Lord, police has recorded, my Lord, say that he had confessed the guilt before the police, my Lord, but there is no confessional statement was recorded. No confessional statement was recorded. And my Lord, rest are all, my Lord, all hearsay witnesses. All, my Lord,
Confessional statement.
the FIR, my Lord, was lodged by the wife, my Lord. My Lord,
Nothing has been executed.
nothing is executed, my Lord. Not even the, my Lord, murder weapon, my Lord.
Confessional statement not exhibited.
Now, my Lord,
Let us see the FIR first.
yes, my Lord, page 4, my Lord, FIR. The afternoon of 23/4/2014, when an altercation was going on between between my husband and me over a domestic matter. Around 4 p.m., the accused, that is my brother-in-law, trespassed into our house. At first, he tried to assault me. My husband tried to resist him. At that time, the accused took the axe, which my husband kept in the courtyard after cutting firewood, and assaulted to death my husband by striking with the axe. After that, the accused fled from the place of occurrence. Therefore, I request you to arrest the accused and impose severe punishment on him after carrying out investigation in matter and oblige. This is Yapi Horo, my lord, the wife of the deceased Mato Horo. Now, my lord,
She was examined as PW1.
one, my lord. Charges were payment 302 and 448. Now, PW1, my lord. 448, my lord. He was in jail.
4 years, 10 months, 9 days.
Now, my lord, PW1, page 10.
Yes.
I know the accused. The accused is my brother-in-law. The deceased Mato Horo was my husband. At around 2-3 p.m., one day at about 8 months ago, the incident took place. I was at home on that day. That day I was at home after getting my health checkup done. I was cooking food at home. My husband told me that he would eat meat. I told him that if I didn't get fish, I would bring meat. At that time, the accused came to our house and assaulted me. Then a scuffle took place between my husband and my brother-in-law. I tried to dissuade them. Then the accused took the axe in his hand, which was kept outside. Then the accused came inside and assaulted to death my husband by striking with the axe. The accused told me that he would also kill me after coming out from jail after 3 months. My husband was killed in the kitchen itself. He assaulted my husband on his head and his head got cracked. The accused went to the police station after killing my husband. At about 8 p.m., the police came. The police took away the dead body of my husband as well, the axe. I've seen the axe in the court today. The accused killed my husband with that axe. When the seizure list was prepared, I put my thumb impression therein. I gave the axe to the police. In the morning next day, I lodged an SIR at the police station. I put my thumb impression in the SIR. The SIR was written by me as per my words. Written for me as per my words. Police prepared inquest report over the dead body. And on the day of lodging the SIR, I put my thumb impression therein. There is no enmity between my husband and brother-in-law, and we did not have visiting terms. I was cooking food after coming from the hospital. And then my husband came and assaulted me in anger for not cooking meat. The houses of the accused, my brother-in-law and ours are adjacent. When my husband assaulted me, I cried loudly. Hearing my cry, 2 persons came. They are Sunil and Rajan. Now, my lord, no Sunil was examined. One Rajan Horo is to examine, my lord. He said he did not see the incident, my lord. At the time he was not even named as a witness. This Sunil, my lord. At that time, my brother-in-law came to my house crossing the concrete wall of my campus. At that time, I was crying. I lodged an SIR on the next day, but the police came on the night of the incident before lodging the SIR. The police examined on the following day. It's not a fact that I did not state to the police that the accused assaulted me. The axe I saw in the court today was ours. It is not a fact that my husband took the axe and when we three tried to snatch the axe from my husband, got injured. It is not a fact that the accused threatened me after 3 months he would kill me after coming out. It is not a fact that I had enmity with the accused, and for that reason, I had given false statement in the court to implicate the accused. I do not know Assamese and I will not be able to read what is written in the SIR. Then, my lord, PW2 is, my lord, the mother of the deceased man. The accused is my younger son. The deceased Mato Horo is my first son, older than the accused. The incident took place last Bohag, April-May month. On that day, I went out for work and returned home around 5 p.m. At that time, my eldest son was lying dead on my veranda. Then I came to know that he died due to a fight between the brothers. The elder brother came to kill the younger brother, and the younger brother got killed. Then the accused went to the police station. Later, around 6-7 p.m., police came from the police station. Police took the ex from the house of the deceased, the house of my elder son, which I've seen in the court today. I went to the police station and put my thumbnails in inquest report while it was prepared in the police station. I did not see the incident. I stayed with the accused. When I came back home, I did not see any injury on the person of my deceased son. PW3 is a co-villager, Lokhiram Kutum. I know the accused. He is my co-villager. I am the village head of the Rongajan village. I know the informant Yapi Haro. The deceased Matu Haro was the husband of the informant. About 1 year ago in the evening time when I was at home, Bango Haro informed me that the accused Buaz Haro had killed Matu Haro. Getting the information, I immediately informed the police station over phone and went to the place of occurrence. That is the code word of Buaz. I saw the deceased lying on the veranda of the house. I saw the injury in the head of the deceased and was bleeding. Yapi Haro showed me the axe and told me that her husband was killed with the axe. While I was at the place of occurrence, the police came and seized the axe in front of me. Exhibit 1 is the sizzle list and Exhibit 1 is my signature. Seeing the axe in the court today, I have recognized it. Material 1 exhibited the said axe. The police took the dead body away from the postmortem examination. I came to know that the accused appeared in the police station on the dead itself. The name of the accused present in the dock is Buaz. I did not see the incident of assault. I did not tell the police that Bango Haro informed me. It is not a fact that Bango did not inform me anything. It is not a fact that I was not informed that Buaz killed Mato. It is not a fact that I did not inform the police, that I did not tell the police that blood was coming out from the head of the deceased. Yapi Haro showed me the axe. She showed me the axe, which I have seen in the court today. Then, my lord, PW4 is Dr. Diptokanto Bora. My lord, he is the person who conducted the postmortem. On 24/4/2014, I was at KCH Tezpur as SDM and HO. On that day, around 12:10 p.m., I conducted the postmortem of the dead body of Matu Haro, 27 years male, son of so-and-so, escorted by Constable so-and-so. Constable Anil Kumar Das, Suresh Haro, Rajan Haro, both cousin of Ganga Haro. External appearance, male dead body was lying on the top of the postmortem table wearing a violet color sporting a white half genji, yellow light towel and brown jangir. Eyes were closed and swollen, mouth was closed, bleeding was seen from nostrils. Semen was present, no faces is seen. Rigor mortis was partial. The dead body was examined after 36 hours of death. Skull intact, skull left parietal and temporal bone broken to several pieces into 2-into-1 area. Membrane torn out of temporal occipital region on left side of brain unbroken under this broken skull with free blood. Thorax and pleural and larynx healthy. Both lungs are pale with occasional black pigmentation. Abdomen, wall, mouth, etc. These are present. Then small intestine. Then last he says, in my opinion, Matu Haro died of head injury. In the cross-examination, it says that in the postmortem examination, I wrote the date on 24/11/2012, April 2012, but it should have been 24th April 2014. So date of the postmortem report was written as 24/4/2012, and under my signature, the date was written as 24/4/14. In the injury I mentioned, the report may be caused by falling on hard substance. Then one Rajan Horo. Now this, whether we don't know whether this Rajan is the same Rajan Malad was supposed to be Milord there as per the version of Milord, the PW1. But if he's the same Milord Rajan Malad, then he says, I know the accused was the son of my uncle. Deceased Matu Haro was also the son of my uncle. The accused and the deceased are own brothers. The occurrence took place about 3 years back. On the date of occurrence, I was at 18th mile in connection with the marriage ceremony. My cousin brother Suresh was telephonically informed at 18th mile, was along with me, that Matu was murdered. So, my lord, he said he was not even there in the place. Deposition of PW6. He is one Mangra Haro. I know the accused. I knew this is Matu Haro. The occurrence took place about 3 years back. I was not at home on that day. While I was returning home, my uncle Robert Haro informed me that my brother, Buaz Haro, had killed my elder brother Matuhoro. I have come to our house and saw my brother Matuhoro lying in the courtyard. Then I called the nearby police. At that time, it was about 6 p.m. After my call, some of the villagers came to the place of occurrence. Gaubara has informed the matter to police. Police came. Police has taken the dead body for postmortem examination. Police has returned the dead body after conducting postmortem. My uncle Robert Horo told me that the accused had killed my brother Matohoro by means of an axe upon his head, crossed by defense. The deceased Matohoro married Yapi Haro, the informant, a Hill tribe woman. It is not a fact that Yapi and my brother, deceased Matohoro, had usually having quarrels. I usually not present in my house, and on that day of occurrence, I was not present in my house. Police has not asked me about the occurrence. I have not seen the occurrence personally. I do not know as to who had killed my brother Matohoro. While I was returning to my home, Robert Haro was going from the place of occurrence. I came to know about the occurrence only on the basis of information given by Robert Haro. I have not stated before any authority except my deposition in the court today that my uncle Robert Haro had informed me that the accused had killed Matohoro with the axe, and thereafter I came to the place of occurrence and I called the nearby people. And on my call, some of the villagers who came to the place of occurrence and Gaubura had informed me the matter to the police, and the police came and took the dead body for postmortem examination in the hospital. When police came and took away the dead body, I was not present as because I went to inform other people about the occurrence. Yapi Haro, the informant is my sister-in-law. I was having good relationship with the informant. It is not a fact that Robert Haro never told me in respect of the occurrence. It is not a fact that I have deposed falsely. Today I am having a good relationship with the informant. Then Surekha Karkita. I know the accused. I also know the informant. I knew this is Matohoro. The occurrence took place about 3 years back. I went to my duty. While I returned from my duty to my house at about 6:30 p.m., my daughter Basanti told me that the accused had killed his brother Matohoro. I have not seen the occurrence personally. My house is near the house of informant and deceased. The informant and deceased, and the deceased and informant usually entered into altercation and tussle, and they also used to enter into assault. So he says that the husband and wife had he used to quarrel, and there was a case of assault also. The information earlier occasion had assaulted the deceased, or the informant on the earlier occasion had assaulted the deceased by means of lathi. PW8. I know the accused. I know the informant. I knew the deceased Matohoro. The occurrence took place about 3 years back. On the date of occurrence, I went to my duty. I have returned from my duty at about 6 p.m. My wife Sabitri informed me that the accused had killed his brother by means of an axe. Police came and asked me to show the house of the deceased, and accordingly, I showed the house of the deceased to the police. I have not seen the occurrence personally. I do not know as to how Matohoro was killed. Prior to the occurrence, the informant and the accused used to enter into altercations and tussle. The informant and the deceased were not in talking terms immediately prior to the occurrence. I have not seen any weapon used in the commission of offense. The informant is my neighbor. I am having good relationship with the informant. It is not a fact the informant had killed her husband. It is not a fact that I had deposed falsely before the court today. I know the accused. This is one Ganga Haro. I know the accused. I know the informant. I knew this is Matohoro. Then in occurrence took place during about 4 years back. On my return from my duty, my wife told me the accused had murdered Matohoro. Although I went to see the dead body, but the dead body has already been taken away, so I could not see the dead body and return. The residence of Matohoro is about 3 kilometers from my house. I do not know how Matohoro died. Police have not recorded my statement, but he is supposed to be one of the witnesses who had accompanied the body for the postmortem. In his evidence, he doesn't say that. Suresh Haro. I know the accused. I knew this is Matohoro. The occurrence took place about 4 years back. I have returned from Bihar on the next morning. I came to know that the accused had murdered Matohoro. Although I went to see the dead body, but as the dead body has already been taken, so I could not see the dead body and return. I have not seen the occurrence and only heard about the occurrence. Police has recorded my statement. I do not know as to how Matohoro died. On 23/4/2014, this is the Millet IO Millet. I was posted as the IC, Borghat Police Outpost. On that day, around 6 p.m., accused Boaz Haro appeared before the Borghat Police Outpost and informed that he had killed his brother Matohoro by assaulting with an axe. He surrendered before the police. Accordingly, I made a GD entry, number so-and-so, and took the accused into custody. I informed my superior authority and left the place of occurrence situated at so-and-so at the house of the accused. I noticed the deceased Matohoro lying in the veranda of the house of the accused. As it was dark, the inquest of the dead body was not conducted at that moment, and I visited nearby the place of occurrence and recorded the statement of witnesses. The wife of deceased produced an axe and informed that the said accused committed the crime. I seized the said axe in presence of the witness. Witness exhibit 1 is the scissor list. Exhibit 2 is my signature. I drew up the case sketch map of the place of occurrence. 3 is the sketch map. 3.1 is my signature place of occurrence. As for the direction of my superior authority, I brought the dead body of the deceased to the KCH hospital, Tejpur. In the next morning, I conducted an inquest report upon the dead body and issued a requisition for conducting postmortem examination of deceased. During inquest, I noticed blood coming out of nose and the mouth of the dead body, and there was also an injury towards the backside of the head. 4 is the inquest report. Exhibit 4 is my signature. On 24/4/14, the wife of the deceased lodged the FIR, which I sent to the Tejpur PS for registration after making the GD entry number so-and-so. Exhibit 5 is the FIR, 5.1 is my signature. 5.2 is the signature, then Officer Tejpur, OC Tejpur, PS, namely Kunjalal Pator, and I know. I recorded the statement of witness of inquest report and also interrogated the accused, and after interrogation, I arrested the accused. During investigation, I collected the postmortem examination of the deceased, report of the deceased. After completion of investigation, I had submitted charge sheet against the accused Boaz Haro under section 302 of the IPC. Exhibit 6 is the charge sheet, 6.1 is my signature. Exhibit 1 is the X material exhibit, which I seized from the wife of the victim and which the accused had assaulted the deceased. Cross-examination by the defense. I received the Azhar on 24/4/2014. The incident occurred on 23/4/14. On 23/4/14, the accused surrendered with the police outpost and took him to the custody. Till arrest of the accused, he was in custody. The material exhibit 1 was handed over to me by the wife of the deceased. During handed over of the acts by the wife of the deceased was not available there. I had made a JD entry for being number so-and-so. Prior to leaving the place of occurrence, the same is available in the case diary. After making the GD entry so-and-so, I started the investigation. On 23/4/2014, I recorded the statements of Lokhiram Kutum, Srimati Yapi Haro, and Soni Haro. I recorded the statement of other witnesses after receiving the FIR, that is Gongo Haro, Rajan Haro, Suresh Haro. At the time of recording the statement of witnesses on 23/4/2014, the informant was available at the place of occurrence. At the time of leading for place of occurrence, UBC Anil Das and one section battalion accompanied me. During preparation of the inquest report, the informant was available in the hospital. Since I have not conducted an inquest at the place of occurrence, the location of the dead body and what circumstances same were not mentioned. I conducted the inquest report at the civil hospital, Tejpur, where the dead body was kept over a stretcher. Though staff of civil hospital was present during preparation of the inquest report, I did not call them to stand as witnesses. I prepared the inquest report about 9:45 AM on 24/4/2014. I left for place of occurrence at 6:45 PM. At night itself, by vehicle, I sent the dead body to the civil hospital. The body was kept in the morgue in the civil hospital at night. What I've noticed is on the dead body on 24/4/14, I mentioned the same in the inquest report. In my case diary, I have not mentioned regarding noticing of injuries on the backside of the head of the dead body before sending to civil hospital for post-mortem. It is not a fact that I cannot say that the injuries found on the dead body was inflicted on 23/4/2014 or during the process of sending the body from the place of occurrence to the civil hospital. I did not send the seized X to the FSL for examination. I did not notice bloodstain on the seized X. In the sketch map, I have not mentioned the location of the houses of the witnesses except the house of the accused and the deceased. When I reached the place of occurrence, I found the wife and the mother of the deceased. It is not a fact that I have not conducted the investigation properly. It is not a fact that I have not conducted the inquest on the dead body in the civil hospital. It is not a fact that I did not conduct the inquest on the dead body properly. It is not a fact that I recorded the statement of witnesses as per the version of the complainant. It is not a fact that I had not taken steps to keep the dead body under escort till conducting the inquest. It is not a fact that due to our fault, the injuries caused to the dead body. It is not a fact that the accused never surrendered to the police before the police post and confessed about killing his brother. It is not a fact that I arrested the accused because the wife of the informant explained me about the accused. It is not a fact that injuries on dead body were not inflicted by the X. It is not a fact that since I had not noticed the injuries on the day of occurrence, I cannot say the injuries of the dead body were caused by the X. It is not a fact that I have not conducted the case lawfully. and submitted the charge sheet against the accused without any material. This is the DW1. He examined one witness, the one Kudra Goramal. I know the accused as the informant of this case. My house is at about distance of 1 kilometer from the house of the accused, but we reside in the same village. The incident occurred sometimes into the year 2014. On the day of the occurrence, myself along with the accused went to catch fish in the nearby river. While we were catching fish, we heard that a marpit had taken place in the village. We came back to our village and went to the house of the deceased, where from the noise arose. We found the deceased lying in the veranda. The name of the deceased was Matuharo. I heard people that the deceased had a quarrel with his wife, Yapiharo. Today I have not come to court to give evidence along with the today I have come to court to give evidence along with the accused. It is not a fact that the accused went with me to catch fish, and as I have stated today in the court. The deceased was the elder brother of the accused. It is not a fact that I have falsely stated that the deceased had a quarrel with his wife on the day of the alleged incident. It is not a fact that the accused, being a close friend of mine, I have suggested suppress the truth from the court to have given false evidence to screen the accused from the legal punishment. It is not a fact that the accused had dealt a blow on the head of the deceased with the axe, and on the day of the incident it caused his death. Now, in his 313th statement, he simply said that these are false evidences. I am innocent. It's similar, all one-line answers, similar statements. And in the end, he said that he wanted to adduce evidence, though he named two persons, only one defense witness was examined. Question number 14. What do you want to say anything else? Will you adduce any evidence on your behalf in this case? I am totally innocent. False case has been filed against me. I will adduce evidence in the case by examining Masik Kandolona and Kundra Borev as defense witness in support of my case. Page 35 is the judgment. Now, first of all, he refers to the case, the points of for determination whether the accused person above named on 23/4/2014 in the evening committed house trespass by entering the house of the informant and thereby committed an offense punishable under 448 of the IPC. When the same day and the time the accused committed murder of Matuharo, the accused of the informant, and thereby committed an offense under section 302 IPC. Before delving into the detailed discussion and appreciation of evidence on record, it will be appropriate to have a brief glance at the evidence adduced by the prosecution side. Let me begin by looking into the medical evidences on record. PW4, Dr. D.K. Bora is the medical officer who conducted postmortem on the dead body of the late Matuharo, son of Sri Joyram Horo, village so-and-so. The examination was done at Borghat GOP GD entry number so-and-so. It was conducted at Konakolata Civil Hospital at Tejpur on so-and-so. The dead body was escorted by Constable Anil Kumar Das, Suresh Horo, Rajan Horo, Ganga Horo. Now, Suresh and Rajan, they say that they did not see the body. External appearances. A male dead body was seen lying on the top of a post-mortem table wearing a violet colored sporting, a white half genji, light yellow towel and brown jangya. Eyes were closed and swollen. Mouth was closed. Bleeding was seen from both nostrils. Semen was present. No fascia seen. Rigor mortis was partial. The dead body was examined around 36 hours after death. Scalp intact. Scalp left parietal and temporal bone broken into several pieces, about 2 into 1 area. Membrane torn over the temporal occipital region on the left side of the brain broken and the broken skull with free blood. Thorax was pleuria and larynx healthy. Both lungs were pale with occasional black pigmentation. Pericardium healthy, heart empty, vessels healthy. Well, the point, my lord, is first of all, my lord,
Only one witness is there.
only one witness, but then
PW1.
there are evidences showing that they were having tussle and she had assaulted the my lord, deceased. So therefore, my lord, and she has now tried to implicate her brother-in-law. So therefore, her evidence doesn't appear to be very, my lord, of sterling quality. She is not a witness of sterling quality which can be relied upon on the basis of
But
which
the medical evidence corroborated her version.
medical evidence might corroborate, but the fact remains, my lord, that someone, my lord, because he was having a strained relationship with the husband. That has been said by the my lord, other two prosecution witnesses, my lord, who said that they were having tussles, and there's one incident where one has been narrated where she had, my lord, assaulted her husband with, my lord, one lucky, my lord. So it's quite possible, my lord, she might have also assaulted, and this person has taken a defense, my lord. He has examined one witness who said that we were fishing in a different place. My lord.
We have to say that
My lord.
rightly reached the finding that plea of LAB
My
must
lord.
fail. And
Okay,
correctly.
even
because
otherwise, also, my lord, even otherwise,
No suggestion
No.
during the entire.
true, my lord, true, my lord. It's there, it's not there, it's not there. That is true. But the fact remains, my lord, my lord. Even otherwise, my lord, if the witness, my lord, PW1, our my lord, evidence is, my lord, full of contradiction. Now, two persons, Sunil and Rajan. Now, this Sunil was not at all examined by the police. He's not even named as a witness. My lord.
It's sufficient.
But then that's what I'm saying, lordship.
And being corroborated by the medical.
No, but the other accused are also saying that she also has a habit of assaulting the accused.
Right.
So therefore, if that is there, my lord, anything could have happened, my lord. It's because the prosecution has to prove the case beyond reasonable doubt.
No,
Here, the two of the witnesses
No,
prosecution.
Mr. Dutta,
My
you
lord.
see, the post-crime conduct of the accused.
My lord.
On the same day, he surrendered before the police station.
My lord, nothing has been.
On the basis of his statement, the IO has recorded one GD entry.
My lord. But that, my lord, that police statement with the police, my lord, that will not be, that cannot be
No,
used as evidence, my lord.
No, the fact of appearance.
My lord.
No, he cannot depose on the merit of the case.
My lord.
But the fact of appearance of the accused at the police station,
My lord.
he is the only person who can depose.
My lord.
Did you make any cross-examination on that aspect?
No, that of course was
Let us
not
see.
lordship.
Let us see.
Cross-examination of the my lord PO, my lord, that lordship will find that page. Yes, my lord, page 27, it starts, my lord. 28 is the cross-examination.
You extracted about your. You extracted from the IOG
My lord.
that it is cited. There is no denial or suggestion.
There is no suggestion. That is there, my lord. That is
No
there.
suggestion.
But then, my lord.
So it is a fact that you appeared
My lord.
on 23rd April 2014.
My lord.
Right. Incident happened. Investigation proceeded.
My lord.
On the next date, the FIR was lost.
My lord.
It appears subject to what you say.
My lord.
This part, somewhat, there was some kind of embellishment on the part of the informant that the accused assaulted her.
My lord.
That part perhaps somewhat.
But that embellishment, my lord, perhaps, my lord, but that embellishment perhaps will not, my lord, of course.
In a chief also she reiterated,
My lord.
but in the cross, the
Yes.
sequence of events
My lord.
she described.
But she said that there is no enmity, first of all. Then, my lord, she said that.
No enmity goes in your favor.
My lord. Now, while my husband assaulted me a crowd loudly, hearing me cry, two persons came. They are Sunil and Rajan.
This part, I don't know.
Now, who is this Sunil? Who is this? They were not named even witness. The police even didn't try to find out as to who they are. So that's a lacuna on the part of the investigation there, because ultimately it's their burden to prove it beyond reasonable doubt. It is a burden of the prosecution to prove it beyond reasonable doubt.
No. First, you have to show that this evidence of PW1 is not believable.
PW1, my lord, mean my humble submission is because, my lord, other two witnesses, my lord, that is why it becomes a little doubtful, my lord. Because the other two, they had no reason, my lord, to say against her. Lordship will see, PW8, he said that I have good relationship. I have not seen the occurrence personally. I do not know how Matohara was killed. Prior to the occurrence, the informant and accused usually entered into altercation and tussle. The informant and deceased were not in talking terms immediately prior to the occurrence. I have not seen any injury, any weapon used in the commission of offense. The informant is my neighbor. I am having good relationship with the informant. So he had no reason to go against the informant. Then, my lord, PW7. PW7, my lord, I have not seen the occurrence personally. My house is near the house of the informant and deceased. The deceased and the informant. There is nothing on record, my lord. No, it's not on that day, my lord. The deceased and the informant usually entered into altercation and tussle. And
But
they
that-
also
that is
used
a previous history.
two, my lord.
No,
So
no.
that shows, my lord,
FIR says
my lord,
informant was assaulted.
my lord.
In chief also she said she was assaulted.
But she was not exact.
We have to shift the grain from the chaff. She was assaulted.
My lord.
Was there any injury?
She was not examined by the police.
There are three kinds of witnesses.
Sure.
One is wholly reliable, one is partly reliable, and one is wholly unreliable.
Only Anil.
Right?
My lord. Because what happens, my lord?
So she was not wholly unreliable. She falls in the either in the first category or the second category.
Well, so far as the lordship's first query, injury is concerned, she was not examined by anyone. There is no statement, neither she has said I was injured, nor she was examined by the
Assaulted me.
assaulted, my lord. It can be a slap also, my lord. It can be a slap.
No,
I mean,
Mr.
how
Dutta,
one,
that is not the question before the court.
my lord.
Question
True,
before the court is the injury is sustained by the deceased.
my lord.
Who caused it? That
Exactly,
is
my
the
lord.
question before the
Exactly,
court.
my lord. Now here is
Then
the
in
case.
respect of assaulting the PW1,
Yes, my lord.
that is not searched. No
Apart-
search it has been submitted.
Apart from, my lord, apart from the fact, my lord, that he has allegedly surrendered, which has not been, my lord, taken out in the cross-examination. My lord, the fact remains is that no one else has seen him, my lord, him in the place of occurrence, except, my lord, what is being said by the PW1. His presence in the place of occurrence has not been established by anyone except the PW1. Is the PW1's version that he had killed me, and from the PW1's version, it appears that they were, in fact, the husband and wife were having some tussle. So her case is that they were having a quarrel. Now, why a third person without? She is saying that the accused did not have any enmity with us. The husband and wife were quarreling. Suddenly, the accused comes in and hits him with an axe, and then disappears. Now he says that she was there, except for her, no one is saying he was there, and that's why perhaps that's what I'm saying. Lord, she said that Suresh and Rajan were there. Then they ought to have been examined to, my lord, find out the veracity of the statement, my lord. So what has happened here, my lord, and compare, my lord, along with that, the evidence of PW7 and 8, who says, my lord, that she has a habit of there were instances where she had beaten her husband with a lathi. So it's been quite possible that she had beaten her husband with the axe also. It's quite possible. So therefore, it's only a preponderance of probability of something, some kind of thing might have happened beyond reasonable. That's why it's not beyond reasonable doubt that it cannot be established that the accused had actually killed. It could have been the other way around also. The wife trying to, shield her for some reason, or maybe someone is trying to blame the accused for that purpose. Now, how he came, his confessional statement was not recorded. The police ought to have recorded his statement. It was not recorded. Simply making a GD entry that he had surrendered before me, my lord, that is perhaps not sufficient. But his recorded statements, at least the confessional statement, has to be recorded.
No, it is not sufficient, but it also lend corroboration to the prosecution version.
But then prosecution story is also, my lord, having said as a version that the husband and wife were quarreling. They were not in a good relationship. The wife had a habit of, or had even used force against her husband. So therefore, the story there is, it doubles, my lord, to a certain extent.
The question is, there is a direct witness. Whether she has given a first account version, right? I witness account. Now, her presence is natural at the place of occurrence. Everything happened inside or in the premises. Now, question is how far it is believable.
But that is.
And
That is.
she falls in the category of wholly reliable because of her version. One version in chief, the accused first assaulted her. Then in the cross, another version. Right? So, or if not wholly reliable, whether she is partly reliable. If partly reliable, along with other evidence, we have to examine.
My humble submission, my lord, it has
Okay, you rest your submission on some other day.
sole witness, my lord, can be a my lord, the basis of corroboration. There is no doubt about it, man. But lordship will see the quality of evidence. Lordship will see what the contradictions are there from the prosecution side. Two people are saying that she quarrels with her husband. She has hit him at times. These are there. So therefore, and there is no one to indicate that this person was present at that point of time.
That is a normal warrant here.
It may be normal, my lord. It may not be normal. So therefore,
Beating
there is
with a stick is
probability of
more than normal warrant here.
There is a probability
Beating with
of
a stick is more than normal warrant here. Quarreling is.
no, but quarreling and hitting is something different. my lord.
Oh no,
Because
that
if
is
you
what
are-
I said.
If you are in the habit of
Normal quarrel is okay.
my lord, that is quite possible.
Beating with a stick, something more than.
It's something more than
Okay.
that. So therefore, a person, if he has the habit of beating my lord, the husband, my lord, maybe my lord has gone a little beyond.
And it was picked up by informants and handed over to the IO.
Rustic village, madam. Village.
He retreated from the place and went to the police. Accused.
That's what is
appearing, madam. You are silent about IOs. So that is one.
They have
Yes,
to-
since we have heard that we can put it on Friday.
Yes.
Friday. Subject to it is not declared holiday.
Propose it on Friday,
Then on Monday, my lord.
but it is not final.
Trial courts are closed, my lord. Court is
that I
holiday,
know.
state government.
That I know. Subject to, I am
Yes,
saying.
my lord. Then on Monday, my lord.
No, when it's Friday. You are not intending to come or what?
No, if it is holiday.
If it is holiday, we will not come
okay,
also.
Yes.
But Mr. M. Dr. Lawrence Amicus Curie, for some time, MS BVM, learned so for a state is present. List the case file.
May I please?
Set of facts in the other one.
Other ones are
Let
also,
us,
lordship, it's
uh,
quite similar.
Let
Quite
us see
similar.
now, but I have to
Yes,
note down the dates.
I'll give the dates. Okay.
What are the events? I may not be able to sustain till the day, till the, till the rising time. So whatever is possible, I'll. Petitioner is same,
Petitioner is same, the unit is different.
unit is different.
Unit is different. So their unit is, let's say, it's manufacturing of galvanized plane and corrugated sheets. And other one was, if you let's say recollect, that was asbestos.
This is steel.
This is galvanized
Steel unit.
plane and corrugated sheets. Here also,
2008,
here also lots of this. 2003 was, 2003 policy was under the 2000 policy only, 2003 policy only, they have intimated that they are going for substantial labor expansion initially.
no, pages.
Then Lordship may kindly come to directly to 169, page 169. So 169 is the prior intimation here, Lordship. But the document they have submitted here, Lordship, the same document 97/2010. So here the intimation is for prior intimation in respect of modernization of our asbestos unit only. So after it, Lordship, 170, page 170.
1 minute.
Page 170 is the Lordship, their application for eligibility certificate. That was done on 16/8/2011. Then Lordship will find page 172.
One.
In this case, Lordship, there was another round of litigation that I'll just point it out.
Eligibility certificate to whom? AIDC.
They applied to AIDC on 16/8/2011. Page 170.
Then what is this? 172,
172, Lordship, what happened in this case here, Lordship?
29.
their eligibility certificate was initially rejected. May I read it, Lordship? Subject application of grant of eligibility certificate under Industrial Policy 2008. Your application submitted on 16/6/2011. This has reference to your application submitted on 16/8/2011 for grant of eligibility certificate to avail incentives under the Industrial Policy 2008. In this connection, we are to inform you the following. In page 23 of serial number 5 of Industrial Policy of Assam 2008 states, manufacture means an activity that brings out a change in an article or articles as a result of some process, treatment, labor, and results in transformations into a new and different article, so understood in commercial parlance, having a distinct name, character, use, but does not include such activity of manufacture as may be prescribed by finance department. Then 2, in the notification dated 3rd November 2009 of Finance Taxation Department, Government of Assam states activities which are not to be treated as manufacture. The following activities shall not be treated as manufacture for the purposes of the Act retrospectively with effect from 1st October 2008. The third item in the list is galvanization, corrugation of sheath or both. Therefore, your application of grant of eligibility certificate cannot be processed further. So in this unit, Lordship, it was initially rejected for a different reason.
Yes.
Then Lordship, what has happened? They have challenged this in the Honorable High Court by filing a petition number 5494 of 2015. Lordship will find the judgment order at 182, page 182.
Yes.
So page 182, Lordship will find the order dated 10/9/2015. So page 183, Lordship will find, heard the petitioner, Mr. M. Nath takes notice for the respondents. The court in WPC number 5342 of 2009 on the question of validity of Rule 57A of the Assam Value Added Tax Rule 2005 made the following observations. Upon thorough consideration of the facts and submissions, we find that Rule 57A, framed by way of delegated legislation, is beyond the competence of the state. The definition of manufacture in the Act clearly discloses that the process of manufacture would mean that the process of change in the product and bringing out a new product or combination of products in the process to bring out a new product would amount to manufacture. The process of making coal from coke will bring a new product from the coal. Therefore, it amounts to manufacture within the definition of section 230 of the Act. Under the guise of the rule making power, the state could not have amended the definition of manufacture to omit or to alter the activities which come within the definition of manufacture. That apart, the decision of the Supreme Court in Mahavir Vegetable Oils Private Limited case Supra succinctly makes a distinction between the legislation and subordinate legislation and the limitation of subordinate legislation. Paragraphs 41 to 44 of Mahavir Vegetable Oils Private Limited case Supra makes it clear that a delegated legislation cannot take away the right that is vested or accrued by way of a retrospective amendment. Therefore, in view of the said reasons, we hold that the amended Rule 57(1) ultravirus the provisions of the definition of manufacture under the Act and beyond the competence of the rulemaking power to alter the definition of manufacture. The entire Rule 57A of the Assam Value Added Tax Rules 2005 being in conflict with the definition of manufacture under Section 230 of the Assam Value Added Tax Act 2003, whatever the items included in Rule 57A, if are in conflict with the definition of manufacture, would be bad in law. Therefore, rejection of the application for grant of license is bad in law. Accordingly, petition allowed. So this was allowed. So their rejection by AIDC was set aside.
Section. That was in, letter.
Lordship.
That was in page 172. 172. The interpretation relied on by the AIDC on the basis of the rule.
That has been
The rule that has been
rejected by the Honorable Court.
the very
Huh?
definition of manufacture
Hi, yes, Lordship.
under 57A
Correct.
has been
Set aside. So AIDC's rejection has been basically set
meaning
aside.
thereby that the observation that application for grant of eligibility cannot be processed further
That's gone.
gone.
That's gone. That's gone. Then Lordship, page 185, Lordship will find
185. Yes.
185 is Lordship, that application after the judgment was declared, order was declared by this Honorable Court. So Assam Roofing has written to Managing Director stating about this, order that they should be granted eligibility certificate since their earlier rejection by the AIDC has been set aside. Now Lordship, page 186. So after the order was passed and the petitioner filed a copy of the order and seeking issuance of eligibility certificate, then Managing Director writes to the Government of Assam, Commissioner of Secretary, Government of Assam, Industries and Commerce Department, and Commissioner of Taxes. That is dated 22/3/2016.
Yes. What?
May I read out, Lordship? This has reference to the subject cited above regarding the grant of eligibility certificate of Messrs. Assam Roofing Limited, a galvanized plain and corrugated sheets manufacturing unit located at Bonda, Narangi, Kamrup, Assam. In this connection, we would like to inform you that the application of the unit for grant of eligibility certificate could not be considered as per clause of Industrial Policy of Assam 2008 and notification of Finance Taxation Department. According to clause number 4.55 of Chapter 4, Industrial Policy of Assam 2008 and notification of Finance Taxation Department number so and so, dated 3rd November 2009 of Government of Assam, Rule 57A, galvanized and corrugation of sheets or both are not treated a manufacture. Thereafter, they writes, however, the company filed petition number 5494/2015 before the Honorable Guwahati High Court for a justification and to consider the case. The Honorable Court issued an order on 11/9/2015 mentioning that the entire Rule 57A of the Assam Value Added Tax Rules 2005 being in conflict with the definition of manufacture under Section 230 of the Assam Value Added Tax Act 2003. Whatever the items included in Rule 57A, if are in conflict with the definition of manufacture, would be bad in law. Therefore, rejection of the application for grant of license is bad in law. Accordingly, the petition is allowed. Copy of the court order dated 11/9/2015 is enclosed as Annexure B for your ready reference. In this regard, we would like to request you kindly to furnish your views on the matter for further course of action on the same. So AIDC writes to the government, Industry and Commerce Department, that you give your views. Now since Honorable High Court has passed the order, what will be your views? Now, Lordship will find page 189. This is very important, Your Lordship. So this letter covers both the cases, Your Lordship. So this is dated 14 February 2017. May I read out, Lordship?
Industries
This has been written by Secretary Government of Assam Industries and Commerce Department to the Managing Director AIDC.
Yes.
Subject court order dated 11/9/2015 on application of Messrs Assam Roofing Limited. Your letter dated so and so. Lordship?
10/9 or 11/9? 10/9 perhaps.
11/9/2015, that order, Lordship, that High Court's order.
10/9 perhaps.
11.
Is it not?
One second, Lordship.
It is not 11/9, 10/9 perhaps.
It must have been a typographical error, Lordship, but they have referred is at 11/9 only.
It is 10/9 perhaps.
They have written as 11/9 only. In all the documents, Lordship, 11/9 they have written.
Where is the High Court order?
High Court order is at Lordship, page 182.
10/9. Okay.
Yes, Lordship. So with reference to the subject cited above. So Lordship, this becomes relevant because there is an argument that Industries Department hasn't given any opinion. That Industries Department is saying in a different voice and Taxation Department is saying in a different voice. So this basically, settles the issue. With reference to the subject cited above, I am directed to inform you that the matter referred to Finance Taxation Department and Finance Taxation Department's views on the matter is reproduced below. Regarding issuance of eligibility certificate under Industrial Policy of Assam 2008 in respect of Assam Roofing Limited located at Bonda, Narangi, Kamrup, Assam, the unit undertaking modernization is not eligible under the Industrial Policy of Assam 2008. And accordingly, the relevant Assam Industries Tax Exemption Scheme 2009 does not provide for any tax exemption to a unit undertaking modernization. Further, the department challenged the order dated 10/9/2015 passed by the Honorable Guwahati High Court holding Rule 57A of the Assam Value Added Tax Rules 2005 ultra vires before the Supreme Court of India. In view of the above position, the department is of the view that in spite of the order of the Honorable Guwahati High Court declaring 57A of the Assam Value Added Tax Rules 2005 ultra vires to the provision of the Assam Value Added Tax Act, the unit is not eligible for tax incentives since it undertook modernization, which is not an eligible activity for the purpose of tax exemption under the Industrial Policy of Assam 2000.
Now, what happened to the challenge?
That challenge has been rejected.
Where is that?
That is not here, Lordship, but as far as my information goes, that SL, that challenge has been dismissed.
Where is there anything tangible here?
Yes,
Regarding dismissal.
SL to rejection, order was no. They don't have it, but like I am informed that has been rejected.
Any pleading,
No, nothing, Lordship.
any pleading,
No,
any
no.
statement
No,
from any side?
from my side, I don't know. I don't think so.
The question bears relevance, that is why I am asking.
Actually, I will take the instruction.
Any statement will do,
Statement. I don't know.
Somewhere.
I could not.
somewhere.
Just a minute, Lordship. 1 second, Lordship.
Because if I cross this stage, I'll forget.
No, Lordship, I understand, Lordship.
Unbelievable text.
I could not find any pleadings, Lordship, to that extent.
Where is the 57A, rule 57A? Any idea?
That is from the web tools and this is not,
No, because AIDC, which is a constituents in the process, they refer to some page 23, serial number 5 of Industrial Policy of Assam 2008. Where is the policy?
policy is like, Lordship, 2000, it is next year.
Hmm?
Page 41.
Page 41. Where is that clause? Page number 23, serial number 5.
41 is
23.
এইটো বস্তু ক'ত আছে এই জামানটা যে galvanized
23. 5, yes. Page 65. Page 65. Then where is that 3rd November 9 notification? That is your scheme.
9 is the tax incentive.
Yes, Lordship. That is there at page
70.
72.
173. 170.
70.
That is from the other provision.
178.
Oh, 73. In 2017.
72. Okay, this is 3rd November. 3rd November.
Oh, you can take this. Yes, 173.
That I have seen. That I have seen. Now, in notification, because AIDC said that it would not process because of these two reasons. One is page 65, definition of manufacture.
So that has been set aside by the High Court.
No, there is something more.
Yes,
And next is 3rd November 2009.
yes,
The
The
where is
scheme.
that they have quoted activities which are
not manufactured, that's why.
no. Come to page 172. In the notification dated 3rd November 2009, Finance Taxation Department, Government of Assam States, quote, right?
Yes.
Where is that quote? In page 173 scheme.
The significant one, I was significant trading. 57. That's the significant one, 37. Because significant one, I think.
Something has been quoted from this notification.
Yes, Lordship, that
Which part?
Lordship is reading 186, correct?
No. Page 172,
170,
AIDC
yes,
mentioned two regions.
yes,
Mentioned
Lordship.
two regions.
The initial,
One is serial number 1.
yes,
That I have found.
they're correct.
Second one is serial number 2. Some quotation had been made from scheme. That is, the scheme starts from page 173. Which part of this notification has been quoted there? Which part?
Regarding the amendment part, Lordship, you will find it in the rules.
Rules.
57
No, I'm correct.
inserted by notification dated 3rd of November 2009. That has been
Come to
mentioned
next
here.
page, 173. That is the notification.
No,
No, that is a different notification, Lordship.
my lord, the 57A, rule 57A was inserted in the rules of my lord, Assam Value Tax Rules 2005 by gazette notification dated 3rd of November 2009. That has been mentioned here, and it has been quoted, my lord, activities which are not to be treated as manufacturing.
On the same day, Lordship.
Same day.
The confusion is because it was on the same day.
Numbers have not been mentioned, otherwise, my lord, it would have been. That's what you will find here, my lord. in the-
You want to say that second part says about
Amendment part.
amendment.
It does-
Say, we can say insertion of rule 57A.
Yes.
Okay. So, second part has been set aside by the division bench.
Yes,
Then that has been, SLP was dismissed.
dismissed.
So this particular second part is no longer in existence,
Correct, Lordship, it's not there.
right? That is the position.
Correct, correct.
So no longer in existence because of Supreme Court or division bench.
Correct.
Because of DB and SC order. Okay, now page 172. Again, first part.
Lordship is referring to page?
172, serial number 1.
Right, right.
The definition of manufacture
Correct.
was quoted. Right? And that there was an interpretation in the policy. But it says, but does not include such activity of manufacture as may be prescribed by finance department. Let us go back to page 65.
Page 65, see, 4.55.
See number 5,
Five, manufacturing.
4.5.
Yes, 4.55.
So, with definition of manufacture, there is one part, then comma, then next part, but does not include such activity of manufacture as may be prescribed by the finance department.
Correct, Lord.
Finance department by rule 57A
They got it.
prescribes certain things which would not come into the manufacture.
Manufacturing.
That has been
Stuck.
set aside, struck off.
Stuck.
So this part also goes.
As far as that finance department part is
that part
concerned.
goes.
That part.
Other first part remains.
First part remains.
Next part goes.
Correct. That is clear.
That is the position.
Correct.
Okay. Okay. In view of the above position, is of the
So,
is of the view. Okay.
so the last line.
189.
So 189, the last line. So there
We
was.
are only on the sequence of events, not on merit.
No problem at all. So in view of the above position, the department of is of the view that in spite of the order of the Honorable Guwahati High Court declaring 57A of the Assam Value-Added Tax Act Rules 2005 ultra virus to the provisions of Assam Value-Added Tax Act. In spite of that, the unit is not eligible for tax incentive since it undertook modernization, which is not an eligible activity for the purpose of tax exemption under the industrial policy of Assam 2008. This is the view and opinion of the Industries Department.
So that is the cause of action.
No, then this was written to the MD AIDC. So AIDC will take a decision on that, on the basis of the opinion given by the Industries Department. So AIDC has taken a decision at page 190.
It is challenged or not? What is challenge in this petition? 16/3/2017. 16.
In between, let's say page 199, let's say 191, let's say may kindly refer to
199.
191. Let's say. That was actually prior to the issuance of the letter by the Industries Department.
Oh, this is challenged. 16/3.
That was annexed subsequent to it. So let's say
14/7. 16/3. Okay, 16.
So this was written on 22nd of June 2016.
Page 191. 16. Okay, read please.
Yes, page 191. So it was written by the Commissioner of Taxes to the Managing Director AIDC directly.
191.
191. Also,
no,
maybe there is some page,
190.
page nation, there may be some
Oh.
mismatch in the page nation. Page 190. it should be.
190.
Yes, Losses.
Commissioner of Tax.
Anurag Goel, IAS Commissioner of
Ah.
Taxes. Has the Lordship got it?
Yes.
Yes, that's the letter. It was directly written to the Managing Director AIDC. So dated 22nd June 2016.
That was prior to
Yes, prior to.
190/89 letter.
Yes. May I read it, Lord, sir? EC application of Messrs. Assam Roofing Limited in connection with court order dated 11/9/2015. Sir, with reference to the subject noted above and the letters under reference, I would like to cast the following views. Plain reading of chapter 4 of Industrial Policy of 2008 clearly exhibits that incentive under the industrial policy is allowed only to a new unit A or B, an existing unit if it undergoes for substantial expansion. A unit undertaking modernization is not eligible for any incentive under the industrial policy of Assam 2008. Similarly, Industries Tax Exemption Scheme 2009 formulated to give effect to the industrial policy of Assam 2008 nowhere provides for any tax incentive to unit undergoing modernization. The order of the Honorable High Court was rendered in the context of inclusion of activities of galvanization and corrugation in the negative list in clause C, Rule 57A. Hence, the claim sought by Assam Roofing Limited for his modernization of plant does not fall within the scope and ambit of the exemption notification.
The second round, there are two
Yes.
rounds
Right.
shown. One is regarding modernization does not include substantial expansion, right? Second round, how he is opining on this Rule 57A?
Then they are saying,
No, because he said the order of the High Court was rendered in the context of inclusion of activities of galvanization, corrugation in negatives list in clause C of Rule 57A. When 57A whole hog has been declared to be ultra virus,
correct.
how can he make comment on it?
No, he has make comment.
Please read.
Yes,
The
later on.
order of was
Later,
rendered in the context of inclusion of activities of galvanization and
No.
corrugation in the negative list in clause C of Rule 57. Let us see again,
yes.
5182.
No, last paragraph, Lordship, may kindly.
Hence.
Hence the claim sought by the Assam Roofing Limited for his modernization of plant does not fall within the scope and exemption notification. But he's saying about the modernization part. He's not saying anything about the 57. Two issues were there, Lordship.
Second ground. Two reasons. Let us understand this. He said the order of the High Court was rendered in the context of inclusion of activities of galvanization and corrugation in negative list in clause C of Rule 57A.
Correct, Lordship.
Hence, the claim sought by the Assam Roofing Limited for his modernization of plant does not fall in the scope and exemption ambit of exemption notification. Now, if we see 182, there is nothing like galvanization, corrugation, something like that. 57A,
Correct.
whole hog.
He has mixed up.
Whole hog has been declared to be ultra virus.
He has mixed up the two issues.
Now,
little
he
bit.
says he combined both. Then, in view of the above, it is emerged that in spite of judgment of Honorable Guwahati High Court declaring Rule 57A of the so-and-so as ultra virus, Assam Roofing Limited is not eligible for tax incentive since it took modernization only, for which Assam industrial policy never provided any incentive. So I don't think second ground has any basis.
No, but he has mixed up the thing. Lordship, actually,
You have to understand.
yes, he actually tries to mean that
I thought that they are the best authorities to understand.
no, he basically, what I understand.
That was a
Lordship,
misconception.
that
Part of it.
what I understood from reading this is that probably he is saying that though Honorable High Court has struck down 57A, even then, since he has taken modernization, not substantial expansion, so his claim for eligibility certificate cannot be considered. That is what he is meaning, Lordship. Probably that's what I understood, Lordship.
He is also meaning which is misconceived. Second ground at least.
He
Which is wrong.
no, what I am. Now, what I understood from reading this is like, it is very plain, Lordship. I understood is that he is,
Maybe my understanding.
yeah, he is saying that 57 is, though 57 is struck off, but this unit will not get eligibility certificate because of. it is
Right,
taking on
super
moderate.
ground one is
Correct.
quite okay.
Correct.
I'm not saying not.
Yes, Lordship, that's it. He may have little
But
bit
if you
mixed
are
up in his
trying to
language.
interpret the second ground
Mixed
in the
up with his
context of the judgment,
Correct, correct.
like the
That line-
Commissioner of
that-
Taxes,
That line is.
I think my understanding is wrong.
No, 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 that line is correct, Lordship. Yeah, what Lordship is
My
saying.
understanding perhaps is
That,
wrong.
that line, what Lordship is pointing out, that is correct, that he should have written like that. That is correct, Lordship. After this exchange of letters, Lordship, that AIDC writes this letter. Please, 191.
Dr. Saraf, one more question. Why page 189 is not challenged?
Melo,
Page 189.
199, you'll also see what he's asking for clarification on 57A only. The last paragraph, no?
No, this is the, according to Industries and Commerce Department,
My lord,
this is a view of the Industries and Commerce Department.
my lord.
Yes. It doesn't cover.
189. Because as you submitted in the earlier petition,
My lord,
referring to something clause 12.6 or something like that,
my lord.
that in the other petition, if I remember
Right.
correctly,
Correct.
that Industries Department is the final interpreter of the industrial policy. Right? They are only constituents, AIDC, Commissioner of Taxes, if I remember your argument correctly. Then this, according to Mr. Kolida, subject to your, this is the final view of the Industries Department on the matter of Assam Roofing Limited.
My lord, what I was submitting in this case, that in this letter, the guidelines have not been taken into consideration. The guidelines which were approved by the industry department had not been taken into consideration at all. The authority is going only by the earlier industrial policy 2008 only. They have missed that the guidelines were issued and that were approved.
Also, then, page 191.
And one reply, which will also ask me, I'm not disturbing, that why it was not challenged, it was addressed to the, not to me, I was addressed by the managing director, by which the copy was annexed, and accordingly, I challenged it.
I was expecting that from you. But you have annexed it.
I have annexed it, because I was forwarded with it, You'll also see the letter of the managing director, which was at page 192. He forwarded the two letters to us.
2 letters. What are the 2 letters?
Well, this is one of the, you'll also find. There will be the letter dated so-and-so from the Office of the Commissioner of Taxes, Government of Assam, dated 22nd June 2016, and Secretary of the Government of Assam Industry Department, Government of Assam, dated so-and-so, which are self-explanatory, considering the views of the two department and industrial and investment policy of the Assam 2008, your case was so-and-so, will not be considered.
So, along with this rejection letter,
My lord,
they furnish the
copies of the two letters.
2 letters, that
My-
is 14 to 2019 also, 17 also.
My lord,
Yes.
So you are aware of it.
I am aware of it. That's why I annexed it.
And according to Industries Council, this is the final
But
view.
subject to corrections, whatever is there, my view is that only.
Thereafter, over it, AIDC cannot take any view.
Well, that correct, but if the view of the industry department is overlooking the approval which was given to the guidelines,
Right. That is why I'm looking at your prayer portion.
prayer portion, because Milord, this main, is the 2017. Which
They
I,
have only acted on the basis of industries department and
that's correct,
commissioner.
Milord. That's correct. Your lordship is absolutely correct, Milord.
Because I was keeping in mind your submission in the other petition that so far as industrial policy is concerned, industry department is the final interpreter.
There is no doubt about it, Milord.
So they acted at the behest of aides.
Milord, by submission only that, Milord. This letter, whichever is issued, I fully agree, Milord. I cannot deny the fact that it should have been there in the prayer, but you'll also will consider the fact it out 2018, 6 years have passed. So, Milord, what was done in 2018? Many things we have learned it, Milord, later on. But if the writ petitioner also finds that these letters which have been issued, they are in the pleadings, they are there. And they have been mentioned that this is not correct.
No, we have to also keep in mind that a thing not challenged cannot be.
Milord, but your lordship, Milord, the judgments which are there, Milord, the prayer which is there, if in the prayer, in the writ petition, they are challenged. In the writ petition, if you find that yes, they are subject matter of challenge.
Because setting aside 14,
If your lordship, Milord, so please, I will, Milord, file an amendment.
I think
petition.
it will, otherwise it will be very
I will
difficult.
file an amendment petition for prayer. Milord.
Technically, we are law is
Absolutely,
also
Milord, I will not dispute it, Milord. I'll file a small,
because setting aside will not serve any purpose.
my lord, absolutely correct,
Suppose
Milord.
you have a merit in your case, then if I set aside, they will again reiterate.
Milord, absolutely, your lordship is absolutely correct. I will take a liberty to file a amendment petition for the prayer within 1 day.
Because otherwise two repetitions.
Milord, absolutely correct. Milord, your lordship is absolutely correct. In fact, your lordship has gone into so minutely that in
No,
fact, I have also missed it.
It is not your submission or Mr. Kolita's or Gogoi's submission, which will be under rather, my observation will be under rather.
My lord, in fact, your lordship, I may plainly speak, my lord, the prayer person, in fact, it was my duty to look into it.
Because suppose you have married and I set aside
Absolutely correct, my lord.
that
Ultimately, no relief will be there.
Industries Department order, immediately the Industries Department will go
Well,
and say that
I just
he
take
is not
liberty.
challenged. How can he has exceeded his jurisdiction?
Well, I pray that.
So
within
we
1 day, my
rest
lord,
here. I will not make any comment further.
I
We
will
rest
make-
here.
I make prayer that I may be granted liberty.
No, it is up to you
Within
now.
1 day, my lord, I file the amendment petition.
Otherwise, very difficult.
Absolutely correct, my
It is
lord.
up to you.
I cannot deny it, my lord. In fact,
Subject to,
no, my lord, subject to the prayer portion, I will keep the judgments also. There are various judgments that the court has the power to modify, but main, if you
because
know,
as per the industrial policy, AIDC or Commissioner of Taxes, they are subservient to the government,
absolutely, my lord.
either industries or finance, whatever. But they are subservient authorities. Not they are not the competent authority. Final interpreter
Is the industry
is the
department,
industries department,
that is government of Assam, my lord.
government of Assam. So AIDC has merely carried out
No doubt. my lord.
the orders of the department.
Right.
And who, according to Mr. Kolita,
Is the final
has
interpreter.
final interpreter, and they have given his opinion.
My lord, I-
Will not make any comment about that,
Ma-
but they,
my lord,
according
merit
to
your lordship-
Kolita, this is the final
my
decision.
lord, the merit, your lordship is not making comment, but at least in the prayer portion, it should come so that your lordship may at least examine it, my lord. So I will take a
Because
liberty.
it has been pending
Well, the first case, your,
years.
well,
So
first,
that is why breaking the division bench, I thought that it will be
well,
properly taken up.
I'm really obliged to lordship, my lord. In fact, in 2017, we also, my lord, in that.
No, I am suddenly
17, my lord.
I could.
Normally, my
notice.
lord, the prayer person, we take it that the prayer person will be properly, so
Huh.
while settling, my lord, the
Yes, we simply postpone it by 1 week.
well, let them file it. Within 1 day or 2 days, I'll file it.
I have noted down the events. Now I am facts on.
Yeah,
facts,
facts
I am
lordship is
clear.
already clear.
And my submission on the,
Now I am clear.
So the
my
fact-
submission on the merit, my lord, I will just because your lordship will be rising thereafter. They will, because division bench, your lordship has, for this case only. Well, that the industry department, while giving the letter, has not taken into consideration the approval and the guidelines. has not taken into consideration. They have gone only simply on the basis of 2008 industrial policy. The subsequent which was there, which was approved, that has not been taken into consideration. If that would have been taken into consideration, this opinion would not have been there.
I'll rehear your submission in a consolidated way for both the petitions now. Facts are clear,
My lordship,
because bulkiness, I thought that let us have the facts clear.
No, lordship, like, yes, senior.
Yes, yes, please, please.
No, what I am submitting, your lordship, is that what my learned senior is submitted. But like while writing this letter, they have referred to, they have stated the modernization. So modernization is not there in the policy. So they have taken these two aspects of operational guidelines, whatever is there in the definition and policy taken into account. And after that, they have.
No, if you can show a single line that the guidelines and the approval was taken into consideration, then
We'll take note of 2003, 2008 and
that will be on merit.
later policy.
That will be on my.
Modernization, substantial expansion, we'll take note of that.
In fact, better lordship is,
When now you can.
well, in fact, your lordship is better because of the facts now. In
Yes.
fact, that better
can
than Mr.
now-
Kalita and me, my lord.
No.
The entire facts are
Apply
now.
on the legal issues,
Lordship. Now only the two legal
only
issues
two
are-
things.
My lord, I will do one thing, my lord. After 2 days, my lord, I will file it and I mention it before your lordship so that your lordship may take up the matter so that, my lord, the matter can be taken up without delay, my lord.
Okay, we can put it on a fixed date.
Lordship.
We can put it on a fixed date.
Yes, yes, my lord, yes.
As you all, bias. Wouldn't like to ask any questions?
31st, if your lordship,
Any, ready? Division mention for your break, could you ask any? Mission ki date? Yeah.
Okay.
you will convenient 31st, my lord. Friday.
Okay, Friday. We'll put it, there will not be much deliberation subject to,
Yes, sir.
their. You know the technical is how to fill in the whatever. Okay, on the request of Mr. Dr. A. Saraf, learned senior counsel, appearing for the petitioners, and agreed to by Mr. Kolita, learned A. Kolita, learned standing counsel, industry and commerce department, and Mr. B. Goy, learned standing counsel, finance and taxation department, and Mr. Das, as Das, learned standing counsel, AIDC. Comma list the case on 31/5/2024. And the cases will be taken up at 3 p.m.
Lord, if your lordship mentioned that I sought for leave and for filing an amendment petition, my lord.
Mr. So and so, on the request of so and so, that additional pleadings will be filed.
By way of an amendment.
On or before 31/5/2024. And as not objected to. Regarding filing,
Regarding.
the merits, I'm aware, quite aware.
Yes. If there is.
After
anything-
filing, you can.
Yes,
No, if they file
As
the
not
case,
objected to.
if there is something.
yes, yes,
To the
100%.
by so, to the request for deferment. List the case also.
If it changes the character, nature of the case, my lord, naturally.
31/5/2014, cases will be taken up at 3 p.m.
Shall, my lord, I file it on before that and get it listed on the same day, my lord.
I think that will be proper, otherwise breaking the division bench is also
So
difficult.
on 31st itself, we'll mention it and get it listed the same day, my lord.
After 31st, I don't know my fate. Right, I may continue with the division bench or may not continue.
My lord,
If I continue with the single bench, then thereafter no problem.
some
Yes,
uptime
yes.
benches judges are there, so it may be that some changes are there. my lord.
Maybe, I am not sure. So till 35 or 31st, I'll be in division bench. Thereafter, I might be here or I might continue with the single bench or division bench, and I don't know. I don't know. That's it. It is not yet out.
Obliging.